The only case to come before us via video conference this morning is State of Ohio versus Thomas R. Holler. Both sides would have 15 minutes to argue, and you would be able to reserve up to 5 minutes for rebuttal, but it appears that the State of Ohio has waived oral argument. So you will have your 15 minutes to argue. Please don't use the names of any victims or minors as we are recording this session, and it will be posted on the our court's YouTube channel. We have read the briefs already. Proceed when you are.
Thank you, Your Honor. May it please the court. I'm Pat Brown, and I have the privilege of representing the appellant, Thomas Holler, in this case. And the issue before the court in this case is whether an officer, in this case a deputy, as part of a routine traffic stop, can order a motorist out of the vehicle to interrogate the motorist about matters that are completely unrelated to the traffic stop. And the trial court on remand, and this case had come up for appeal before, and on remand, the trial court held that the deputy in this case was justified in ordering Mr. Holler out of the vehicle to question him about why, in the deputy's view, he appeared nervous. And it's our position that the trial court's holding in this case runs afoul of both State versus Evans, which is cited in our brief Supreme Court precedent, and State versus Robinette. And the deputy in this case, to his credit, was very honest at the suppression hearing. If you look at the transcript about why he had ordered Mr. Holler out of the vehicle, and the deputy was very forthright. He said it had nothing to do with the traffic stop. I was ordering out of the vehicle to question him about why he appeared to be nervous. So he didn't try to hide the ball on that issue at all.
Attorney Brown, did he?
Yes,
I assume then he didn't testify that this was for officer safety or convenience of the officer or anything to order him out of the vehicle.
He did not. I read the transcript again yesterday, Your Honor, and there's no testimony in the transcript that he was doing this for officer safety. And the state from the beginning has tried to justify the deputy's actions in this case under Pennsylvania versus Mims, and I'm sure the court is very familiar with that holding, where an officer can order a motorist out of a vehicle as part of a traffic stop to effectuate that traffic stop. And that holding in Mims was rooted in officer safety considerations. However, Mims never held that an officer can order a motorist out of a vehicle as part of a routine traffic stop to essentially go on a fishing expedition and ask about matters unrelated to that stop. So it's our position that Mims simply doesn't apply in this case. And I think that the Ohio Supreme Court's holding in State versus Evans is instructive in this regard. And in Evans, the Ohio Supreme Court, and that's 67 Ohio State 3rd 405. In Evans, the Ohio Supreme Court held that a Mims order does not automatically bestow upon an officer the right to conduct a Terry pat-down absent reasonable suspicion. I think by extension, that precedent applies here, that a Mims order does not automatically bestow upon an officer the right to interrogate the motorist about matters unrelated to the traffic stop. The other precedent that is instructive in this case is State versus Robinette 2, which held that an officer can briefly extend a routine traffic stop to ask about the presence of contraband. But once the motorist says, no, I don't have any contraband, and the officer doesn't have any reasonable suspicion to believe otherwise, that's the end of the matter. So, in this case, while Mr. Holler was still seated in his vehicle after Deputy Mills came back after running his information, and everything came back clean, there was no warrants, Mr. Holler had a valid license. Deputy Mills asked Mr. Holler, is there any contraband in the vehicle? And while Mr. Holler was still seated in the vehicle, Mr. Holler said no. Under Robinette, that should have been the end of the matter. If the deputy was going to write him a citation, that would have been the time to do that. If he was going to let him go with a warning, that would have been the time to do that. What the deputy instead decided to do is order him out of the vehicle to continue to interrogate him. And it's our position that that was a violation, a constitutional violation, and that violated the precedents in State versus Evans and State versus Robinette. After Deputy Mills ordered Mr. Holler out of the vehicle to interrogate him, that's when, after all that occurred, that's when Mr. Holler said there was an open container of beer in the vehicle. And then he also mentioned a firearm. And at that point, Deputy Mills searched the vehicle. But it's our position that the constitutional violation had already occurred prior to that. The act of ordering Mr. Holler out of the vehicle for no other reason than to just interrogate him about why, in the deputy's view, he appeared to be nervous. The deputy did not have any basis to do that under the law.
Counsel, why, in reading the briefs, and I realize we're at the second time this has come up, so, but in reading the briefs this time, I got the flavor of the indication that the reason for the traffic stop had not been completed at the time the officer asked Mr. Holler to leave the vehicle. In other words, that either the search on the database wasn't complete or the ticket hadn't been completed. So I know we have case law regarding the timing of these, getting the information and completing the traffic stop. What is it your understanding from the transcript that the entire matter had been completed and then that he had returned Mr. Holler's documents to him? And
it's my understanding from the transcript and the video, which states Exhibit 1, which is part of the record, that Deputy Mills had already, and he testified about this, and it's apparent from the video, Deputy Mills had already run Mr. Holler's information, and he testified explicitly, and it's in the transcript, that there were no warrants and there were no issues. His license was valid. So your question about whether he had already done that part of it, yes, that was complete. Now, had he written a ticket at that point? No, when he ordered him out of the vehicle. But Deputy Mills, again, this goes back to whether this was justified under MIMS. He wasn't ordering him out of the vehicle to effectuate the traffic stop. He completely abandoned the mission of the stop, which would have been either to give Mr. Holler a warning or to write him a ticket for the taillight violation or left of center violation. He completely abandoned that mission. So if you look at the precedents that you're referring to, Your Honor, State versus Rodriguez, and this court, and that's the United States Supreme Court, and this court has some precedents that we cite in our brief, State versus Rackow and King and Bramley. The deputy has to be diligent in pursuing the objective of the traffic stop, and that's what Rodriguez says. So had he written a citation? No, but he abandoned the traffic stop and instead ordered Mr. Holler out of the vehicle so he could interrogate him about matters completely unrelated to the traffic stop. So that doesn't fly under Rodriguez or this court's precedents in Rackow and Bramley. So to answer your question, had he written a ticket at that point? No, but it's our position that he completely abandoned the mission or the purpose of the traffic stop, which would have been to write a ticket. He made no effort to write a ticket. He simply asked him out of the vehicle to interrogate him. So he improperly expanded the scope of the traffic stop. I hope that answers your question, Your Honor.
it does. It raises another question, however. The original motion to suppress in the trial court, am I correct in remembering that it is phrased as he should not have ordered him out of the vehicle to perform field sobriety tests?
That's correct. Well, the motion, yes, and the memorandum in support broadened it a little bit and said he shouldn't have ordered him out of the vehicle either to have him perform field sobriety test or to expand what was a traffic stop into a criminal investigation. Now, the reason it was worded like that, if you go back and you watch the video, after Deputy Mills orders Mr. Holler out of the vehicle, he says, well, at some point he says, well, I'm going to have to check your eyes. which she's clearly referring to the HGN test. The other thing, interesting thing is on page 32, and I just noticed this yesterday, on page 32 of the suppression transcript, Deputy Mills openly admits that part of the reason that he ordered Mr. Holler out of the vehicle was to conduct field sobriety tests. He says that on page 32 of the suppression transcript. Now, the state kind of tried to, I think, realizing that he didn't have reasonable suspicion, to expand this into an OVI investigation. And he openly admitted he didn't have reason to suspect, and that's in the suppression transcript. He did not have reason to suspect that Mr. Holler was impaired. The state kind of tried to change its argument at the suppression hearing and say, well, no, he was just ordering him out to interrogate him about why he was nervous. Well, frankly, it doesn't make a difference whether he was ordering him out to interrogate him about why he was nervous or ordering him out to conduct field sobriety tests. It wouldn't make a difference. He has to have independent, reasonable suspicion to do that. Now, I would also note the state never argued, either at the trial court level or in either appellate court brief, that the motion to suppress did not sufficiently put them on notice of the issues. The state has never raised that argument and does not raise that argument in this appeal, so the court shouldn't consider that. The state hasn't argued that. Everyone was clear on what the issues were at the suppression hearing, whether Deputy Mills' act of ordering Mr. Holler out of the vehicle, whether that was to conduct field sobriety tests, which the record supports that. He admits that on page 32 of the transcript, or whether it was to interrogate him, or both. It doesn't matter. Our position is he needed independent, reasonable suspicion to do that. So, and that brings up another issue in the trial court's entry after remand, the one that's being appealed now. The trial court says, I'm paraphrasing a little bit, that there was no evidence to support the allegation that Mr. Holler was detained for the purpose of field sobriety tests. That's simply not true. There's plenty of evidence. Number one, Deputy Mills admits it on page 32 of the transcript. Number two, if you watch the video, Deputy Mills tells Mr. Holler, I'm going to check your eyes. He's clearly referring to the HGN test. That's why the motion was worded that way. When we watched the motion initially, before the motion to suppress was filed, or when we watched the video, I'm sorry, before the motion to suppress was filed, it appeared very much like an OVI investigation. He's saying, I'm going to check your eyes. He's ordering him out of the vehicle. So that's why it was worded that way. I hope that answers your question about that, Your Honor. So,
Does. Thank you.
The one other issue, and I just wanted to mention this, I don't think the court has to address this, but reading this court's decision on the first appeal, it mentioned the issue of consent. I just want to point out the state, either at the trial court level in the first appeal or the second appeal, the state has never argued that Mr. Holler consented to a search of his vehicle. That was not an issue. And it's clear from the video that he did not consent, and Deputy Mills never testified that he consented. For some reason, after the suppression hearing in its first entry, the trial court sua sponte raised this issue of consent. That was never raised by the parties, and it would be the state's burden to raise that if they wanted to argue that Mr. Holler consented. The state never made that argument, so I have no idea why the trial court did that in the first entry. But if you look at the trial court's second entry, the one we're appealing now, the trial court doesn't mention consent. It may have recognized its mistake in that regard. So consent is not an issue for this court to decide. I just wanted to point that out from our perspective. That's not before the court. It's just not an issue here. So that, yeah, I guess in conclusion, we believe the trial court erred in holding that, Deputy Mills' actions were justified in this case. That he should have had independent, reasonable suspicion, which he openly admitted he did not. So that's our position. Does the court have any other questions that I could answer about this? I know it's the second appeal, a little bit confusing procedurally, but anything else that I could help out with today?
Seeing none.
Okay. Thank you. Thank you for your time, Your Honor. Appreciate it.
Thank you, Attorney Brown, for your presentation today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website. This is our last scheduled video conference for this year.